Welcome to everybody who is here, and particularly, of course, to Professor Richard Sherwin, who I am as ignorant about his work as many of you in the room, because as I've been explaining to him, those of us who've been teaching law in Cambridge for many years often do it in a very boring way, and we don't know anything about these new interesting ways of thinking about law, and we are going to be, I think, instructive. The audience, you're a really interesting cross-section of people, I think, from undergraduates to postgraduates to academics to all sorts of people I don't even recognise. So at the end, when we get into questions, discussion, it may well be useful if you're happy enough to say who you are, because Richard is very interested in knowing who you are when you respond to what he's going to say. I'm not going to introduce him in any detail except to say that he's here because of Shubha Mukherjee, who has a very interesting project going at the moment, which is interdisciplinary in a really interesting way, and it's crossroads of knowledge in the early modern something. Do you know what the project is?
Yes. Well.
And it's interdisciplinary, and Richard is here talking interdisciplinary professor with people within the English faculty. And again, I don't think we do as much of that as we should. You know, it's quite exciting for people in the law faculty to talk to the Institute of Criminology, let alone the English faculty. So anything we can do to break down some of our barriers. Visualizing Law is one of your books, and you might tell us a bit more about that later. Professor Sherwin, as you know from the blurb, is Wallace Stevens Professor of Law and Dean for Faculty Scholarship, Director of the Visual Persuasion Project at New York Law School, and I'm going to sit down and you're going to talk. Thank you very much.
Thank you. Thanks so much, Nikki. Thanks for the invitation to come speak to you. It's wonderful to be here in Cambridge. I consider this place a kind of intellectual oasis, and in these challenging times, that's no small thing. This approach that I'm bringing to my teaching actually is rather marginal in the States as well, but not in practice. The premise of my talk is that the way law today is being practiced in the courtroom and in law offices has been transformed by new forms of visual technology. And what that means essentially is that words are giving the stage of law a new kind of context. The meaning of images, the way images convey different kinds of expressions of sorry, I'm losing my thought. Let me start with this. The idea of the adversarial context in which law pursues truth as a kind of, shall we say, a cauldron of opposing narratives is something that hasn't really been explored in the context of visual images. How does the truth-testing methodology that we've inherited in the Anglo-American tradition, how does it operate when we shift from the traditional word-based mode of communication to screens? This really hasn't been studied in law school. It's just beginning to be written about, but it raises a lot of really interesting questions. For example, when you think about visual evidence or watching images as the basis of truth in the search for truth in a given case, what exactly are we looking at when you think about it? When one watches an evidentiary image, who exactly is testifying? Is it the person or the object or the scene that's being depicted? Is it the image or the image maker who frames what we see? Is it the digital program that is used in post-production to frame the image? What does it mean to cross-examine an image in court? So these are not simple matters, and in fact, over the years, I found that the more one considers the issues involved, the trickier it becomes. So I want to advocate today in favor of training jurists to become more visually literate, so that the adversarial tradition may flourish under new technological conditions. And to attain that, in the face of these changing visual technologies, I think we have to realize what is at stake. We need to learn new methods of inquiry, new forms of knowledge, new aesthetic codes, so that the integrity of the truth-seeking process may be preserved. The thing that I'm going to talk about today has to do with what happens when images migrate to the screen. What we note is that images live on the screen the way other images do in various cultural contexts. And that means essentially that the logic of visual association and affective engagement have now become part and parcel of the legal reasoning process. And in law school, the word-based epistemology of law is linear and logical. The syllogism is the main tool. But images do not function that way. They don't function as propositions. They function in the way of visual association, conjuring associated images and memories that are saturated with affect. So the question is, how do we know how to assess the impact of these kinds of new forms of visual communication in the truth-seeking process? How do we know, for example, when affect has become more prejudicial than probative in a given case? How do we speak about this as legal advocates? In my seminar on visual persuasion, I believe I would deem it a success if my students knew how to stand up and say, "I object to red, Your Honor. I object to red." Why? What is it about this particular focus, a crime scene, a pool of blood, dwelling somewhere? Is it more prejudicial than probative? What is it conjuring? So these are the kinds of things, the kinds of questions and controversies that I want to engage. And I think the place to begin is with storytelling. That's another thing that I never really learned much about in law school, although when I became a prosecutor in New York, I rapidly realized that the more I lectured the jurors about rules, the less contact I made, and that, as studies have shown, jurors tend to construct meaning with narrative. Facts are made to cohere on the basis of the stories that are told in court. And the best lawyers that I've seen in court are the ones who know which particular story type is optimal for a particular case. So, for example, prosecutors are rather fond of telling whodunit stories, adding up clues that solve the mystery of the crime in a criminal case. Well, here's an example of a visual version of a whodunit that's taken from a prosecutor's, Marsha Clark's, summation in the O.J. Simpson double murder trial in 1984.
We have the Rockingham blood trail. We have the Rockingham glove. with all of the evidence on it. Ron Goldman fibers from his shirt, Ron Goldman's hair, Nicole's hair, the defendant's blood, Ron Goldman's blood, Nicole's blood. There he is.
There he is. So this is the visual equivalent of solving a mystery. The puzzles snap into place. Each puzzle piece, a clue, a bit of evidence that's been submitted in the course of the trial, and you have the mystery solved in the end. Here's another one, a graphic I'm rather fond of that was created by Christopher Ritter. Very simple, very expensive, and very interesting. I'd ask you, I'm going to play this, and I'd ask you to tell me what genre do you think is being exploited? What narrative genre is being exploited in this with this visual? It was used in the Timothy McVeigh murder trial in 1997. This was a domestic terrorist bombing in Oklahoma City, Oklahoma. The Federal Murrah building was bombed. Hundreds of people died. And the graphic is just this clock face and an audio of a very boring administrative law meeting that was taking place at exactly the time of the blast. And it's important to know, as you look at this, that the explosion on April 19th, 1995, occurred at precisely 9:02 a.m. Let's see if you can identify the narrative genre this is using.
Basically what happens is we'll present evidence, hear evidence from the applicant, ask questions, hear from the protestants with regard to why the application shouldn't be granted, and I take all of that information under advisement and draft up what's called a findings of fact, conclusions of law, and a proposed order, which will be mailed to all the parties about 15 days before the Oklahoma Water Resources Board meets. They actually, they sit in this room and discuss the application and vote whether to approve or deny the application. So they're the decision makers. And you'll receive a copy of my proposed recommendation and can attend that board meeting and present your information directly to them or arguments directly to the 9-member board. They generally meet the second Tuesday of every month. So you'll be advised of that. With regard to this proceeding, basically there are 4 elements that I have to receive information regarding.